Hey everybody, Jonas Callis here of the Hurt at Work Workers' Compensation Law Firm. Many of you may know me as the Workers' Comp Guy. First, the obligatory disclaimer. The following information is for informational purposes only and does not constitute legal advice, nor does it create an attorney-client relationship with anyone. So, if you're familiar with my website, my videos, you hopefully kind of have an understanding of what an injury by accident is, and that you need to report the accident and the injury within 30 days, and et cetera, okay? But what happens after that, okay? What happens after you report that accident injury to your supervisor? And so today I'm going to talk about the process, just the general process of what happens in a workers' compensation claim. From my experience, I've found that many attorneys kind of overlook this part of the information when they're dealing with their own clients, because it's such a standard thing that happens that they don't even think about going into it and explaining it. But what I've found is when I explain it to my clients, they feel more comfortable with, because they know what to expect. There are no surprises, typically no surprises. There could always be surprises, but there aren't as many. There certainly aren't as many, right? And quite frankly, it makes me look good, okay? Because like I'll tell my clients, look, this is probably how this is going to play out. A, then B, then C, then D, okay? And like I look like Nostradamus, right? When sure enough, as the claim progresses, A happens, then B happens, then C happens, then D happens, right? Like I can see, and I'm not trying to scam anybody. I'm telling you because I know that's what happens because I've done it so many times. But it kind of puts everyone's mind at ease, right? When they're not going to be surprised all of a sudden with, whatever is filed by the other party. Okay, so with that being said, because again, let me back up too. Like this information that I do is largely it's geared for injured workers who aren't attorneys, right? So it's to help injured workers kind of understand what's going on in the workers' compensation process and be able to at least, try to handle their claim somewhat competently, okay? That can be tough sometimes. I mean, that's why there are attorneys, but, some claims can be handled by an injured worker by themselves if they understand what they're doing, and if the claim isn't too complicated. And hopefully this is designed to provide information so injured workers don't make mistakes that are actually fatal to their claim, okay? So typically what happens after an injured worker reports his or her accident to his or her supervisor, manager, shift manager, general manager, foreman, whatever, right? What happens usually, a lot of the times, if it's an emergency situation where the injured worker needs emergency medical treatment, the injured worker should go get medical treatment for the emergency injuries, okay? But a lot of accidents aren't, but they still need medical treatment. But it may not be like you're bleeding profusely from a deep laceration or something like that, okay? So in those cases where you don't need medical treatment, because if you need medical treatment, you should already be on your way to the hospital. But sometimes what will happen is you don't need emergency medical treatment, and you'll be taken, you'll go to your supervisor's office or whatever, and you'll fill out an accident report. A lot of times it's just a paper form that you'll either fill out by hand, or your supervisor will fill out by hand with information from you, or maybe type it into a computer and then print it out or whatever. Some insurance companies will actually, they'll have a phone-in system, but you're basically doing the same thing, right? You're phoning in, you're providing what happened, what date, what time, where were you, who's technically your employer, things like that, right? What did you hurt, that kind of thing. Were there any witnesses? So that's another way that an accident report will be created, okay? And again, but let me back up because it's very important, and I know I've said it already, but that's where the injuries don't require emergency medical treatment, right? If you're bleeding to death, you don't need to be sitting in an office somewhere worried about completing an accident report. There'll be plenty of time for that. There's a 30-day deadline, right? You have to report it within 30 days, but if you need emergency medical treatment, get it, and then report it on the 4th day or the 3rd day or 2nd day or the next day, whatever, okay? So after, to the extent the injured worker doesn't need to seek emergency medical treatment and goes and fills out an accident report with the supervisor, typically what happens next, and what's supposed to happen, is the supervisor will provide what's called a panel of physicians. All that is a list of three or more physicians. The physicians should be of a different practice, but these are workers' compensation these are doctors who have agreed, right? They agree, because not all doctors treat workers' comp injuries, but a lot of doctors do, right? So these should be a list of 3 or more doctors, that all of which treat workers' compensation injuries. And the injured worker selects one from that list and goes, and that's where they get their treatment for their work injury. Okay. Now, if you get to that point, and there's information on my website, if you get to that point and you're offered a panel and you really don't have a good reason to refuse anyone from the panel, and you just go ahead and treat with your primary care physician, that may not be covered, because the employer has an obligation under the law to offer a panel of physicians, and the employee unless there's something wrong with the panel. And sometimes there is something wrong with the panel, but unless there's something wrong with the panel, the injured worker has an obligation to treat with whatever physician they select from that panel. And sometimes this is why it's helpful to know an attorney, though, right? Because I've seen a lot of these panels, and some doctors, they just don't. They think that a lot of people who claim to be injured at work, especially the more severe injuries, they're just, for whatever reason, they're skeptical of that, and they're just not as friendly to the injured workers, I guess. And let me tell you something: the employers and the insurance carriers, okay, they know that, right? Like, word gets around of the physicians and the doctors that aren't as friendly towards injured workers, right? And you can bet money that those doctors are going to be the ones on the panel, or at least they'll find a spot on the panel. They'll be one of them. So that's why it's sometimes helpful to have an attorney who's done this kind of thing before, because a lot of times, like, I could spot, you don't want to choose this one from the panel, choose one of these 2, or that kind of thing. Okay. So anyway, now let's back up a little bit. Once the accident is reported, remember, electronically, or fill out a written paper form of an accident report, or call it in. Once it's been reported, the employer or the workers' compensation insurance company is required to file with the Virginia Workers' Compensation Commission what's called a first report of injury. It's abbreviated. You'll see it a lot of places if you have a workers' compensation claim. It's abbreviated capital F, capital R, capital O, capital I. A lot of people just call it a FROI. Okay. The filing of the FROI will prompt the commission, the Workers' Compensation Commission, to do a couple of things. Number one, it'll just issue kind of a notification of injury correspondence to everyone. The injured worker doesn't have to do much with this. Surely keep it for your file. And I guess make sure the date of the accident is correct, but you really don't have to do much with this. The other thing that the commission will issue is what's called a VWC Form 5, which is also referred to as a claim for benefits. I talk about claims for benefits pretty much ad nauseum on my website, and I have videos about it. So claim for benefits is important. It's geared to the injured worker. The injured worker must complete that, and fill it out and file it with the commission within 2 years of the date of accident. A failure to do that will result in the claim being time barred a lot of the time by the statute of limitations. I have video on the statute of limitations, and I have information on my website, so I'm not going to get into it too much here, but just the takeaway is, know that you will need, for an injury by accident, you will need to file a claim for benefits with the commission within 2 years. Now, like I said, the notification of injury correspondence is just a letter advising of an accident and injury has been reported to have happened on such and such date. Okay, injured workers don't need to do much with that. Just keep it for your file. Now, here's a ninja tip though. The FROI that was filed, that created the issuance of that notification of injury, the FROI is filed by the employer and its workers' compensation insurance company. So that is going to include their narrative of your accident, what happened, why it happened, what body parts were injured, this, that, and the other, okay? So this is something that the injured worker should review. Keep it for your file, certainly, but also review it, okay? Review it for inaccuracies. If you find an inaccuracy in there, it's because it was reported wrong somewhere along the line, okay? You may have reported it right, and then it got twisted around somewhere. So if you find an inaccuracy, that's kind of a red flag for you to know where you may need to get corroborating evidence, because you're obviously going to testify the opposite, but you may need some additional evidence to overcome, because obviously they have information somewhere that says the opposite, okay? So do check the FROI for inaccuracies, make notes, and understand what the FROI is saying happened to you. All right, so the claim has been filed. What happens within the insurance company is, or actually the claim hasn't been filed yet, but there's been a report of the accident. What happens at the insurance company is an insurance claims adjuster will be basically assigned the case, the claim, and asked to investigate it, right? And they have their standard procedures. They basically have it's almost check the box. They have things that they have to do, and they check the box once they've done them, okay? One of the things that they do, and in most cases they do, not all but most, is they will contact the injured worker and ask to do a recorded statement. A recorded statement is a list of questions that they ask injured workers, all right? They're not just, a lot of injured workers are somewhat skeptical of insurance companies, but a lot of these questions just will come across as kind of standard, questions to be asked, but a lot of them are not, okay? The insurance claims adjusters understand Virginia workers' compensation law. I know that they do because when I worked with the insurance defense firm, I used to train them, okay? So they would ask me questions like, what should I do in this claim? What kind of questions should I ask? What's the law in Virginia at this time? So they ask those questions in the recorded statement for a reason. They will use your answers later. It's recorded, right? So that's called the recorded statement. They'll ask your permission at the beginning and at the end of it. They will use your answers later against you, okay? They won't use your answers for you, but they'll use your answers against you. If your answers seem somewhat inconsistent, if your story seems to change, they'll use your earlier answers to impeach your credibility as a witness, right? They'll also use what you explain in the recording, your actual answers, the substance of your answers, to undermine, to the extent it's different, to undermine what you're saying later. Okay, so I prefer for injured workers to not give recorded statements. Here's the thing, promise me this. If you do feel inclined to go ahead and try to cooperate, if you feel like you're cooperating and that may help your claim along, okay, fine, but do this. Check out my video on recorded statements first, and check out my website about recorded statements first before you do a recorded statement, okay? At least have some knowledge about it going in, okay? Because those recorded statements can be detrimental to claims. I used them in my past life to get claims denied, to make witnesses look like their testimony was inconsistent and therefore their story was changing, okay? So they will use the recorded statement to deny your claim, to be clear. But now, so that's the FROI and the notification of injury. Now I'm going to talk a little bit about the other form, the VWC Form 5, also called the Claim for Benefits. This one is directed towards the injured worker. And like I said, this one is important. You have to file the claim for benefits within 2 years of the date of accident if your accident if your injury was caused by an actual accident, okay, specific identifiable accident. To be clear, the employer's filing of the FROI is not a substitute for the injured worker's responsibility to file that claim for benefits with the Workers' Compensation Commission, not the insurance company, with the Workers' Compensation Commission within 2 years of the date of accident. All right. Otherwise, your claim will be time barred or barred by the statute of limitations. All right. Now, once the Workers' Compensation Commission receives the claim for benefits and usually some supporting medical records that you have supporting your claim, they will issue a 20-day order, okay? And now the 20-day order isn't as much geared towards the injured worker. You should pay attention to the 20-day order and how the insurance company and the employer respond. But it's not geared towards you, it's geared towards them, and it usually says that on it, okay? But it's going to ask them whether they accept the claim, whether they deny the claim, et cetera, what parts they accept, what parts they deny, all right? Now, why are they issuing this? Well, because you filled out a claim for benefits, right? The claim for benefits is saying something like, on this date I hurt my butt, right? And I want these benefits, something like that, right? So the employer and its insurance company are now responding. They we've talked about it. They've done some sort of investigation. They've tried to get you to do a recorded statement. They've probably talked to witnesses, co-workers, et cetera, right? So they're now tasked with having to respond to the commission to accept, deny, accept in part, deny in part, or whatever. Okay, when they issue the 20-day order to the employer and the insurance company, they will send a follow-up email or letter to the injured worker confirming that the injured worker has filed a claim for benefits with the commission as well. Okay, you should, in the same way you will review the FROI and you're going to review the 20-day order response form, you should review the letter to make sure it says what it should say, right? When your accident happened, what the accident was, what the body parts were, anything that it says on it, you need to double check for accuracies, okay? If it's inaccurate, contact the commission, let them know. Definitely save a copy of that letter for your file, just in case, because sometimes things will get lost in the mail, the insurance company's file will not have all the information or whatever. It's nice to be able to say, no, I got this letter from the commission right here saying I filed it on such and such date, which is definitely within 2 years, the 2-year statute of limitations, right? So it's good to have that on hand. All right, so in theory, the insurance company and the employer have 20 days to respond to the 20-day order. That's why it's called that. If they agree to if they agree entirely to what has been claimed, the benefit, the accident, the injured body parts, the benefits requested, like wage loss benefits, medical treatment, whatever, they should be sending an award agreement form to the injured worker for review and signature. Okay. They can also indicate on the form that they're agreeing to a medical only award, is what it's called. That's where either the injured worker may claim only medical benefits, or the injured worker claims both medical benefits and wage loss replacement benefits, but the insurance company is only agreeing to the medical award because they have some sort of issue or problem or dispute with the claim for wage loss replacement benefits. So the other thing they can do, in addition to accepting the claim entirely or accepting the medical aspect of the claim, they can deny the claim. If they deny the claim, the rules of the commission require them to file all the medical records that they have in their possession with the commission. That way, and when they file them, they should send a copy to you. It's good to have, obviously keep all those things that you get from the employer, the insurance carrier, medical records, anything like that, you should keep in your file. Sometimes the employer and the insurance company will advise on the 20-day order response form that the claim is being investigated. I don't like that answer. To me, that's a delay tactic, but it is what it is, and it's often that nothing harmful comes to them by doing that. So when that happens, you can always follow up with the commission and say, hey, go ahead and set this for hearing, right? Because the longer they delay, the longer they're investigating, right? That means you're not getting benefits during that period. So you can always contact the commission and request that your claim for benefits be referred to hearing. A lot of times they may do that anyway if the employer and the insurance company just indicate it's being investigated. We don't have a response at this time. So with the 20-day order, like I said, the injured worker doesn't need to do anything. Okay. That said, sometimes in the 20-day order response form, some insurance adjusters will provide more information than others. Okay. Some of them will provide a lot of details as if they're denying the claim, why the claim is being denied. patient injured worker didn't report it quickly enough or timely. Also, witness says injured worker wasn't hurt at work, hurt at home, and then tried to fraudulently claim it was at work. Whatever, right? You'll get an idea of why, where they're coming from. And again, that's something that you note for your file, because if it did happen at work, you'll need to, in addition to your testimony, who witnessed it? Are there any video surveillance cameras where the accident happened? When you went to the doctor's office, what did you tell them? What did the doctor's notes say? Did you go to the doctor before that date for the same injury? That kind of stuff, okay? Some common reasons for denying claims when they do deny the claims are failing to timely report the accident and injury to the employer, failing to timely file a claim for benefits with the commission. That's what we just talked about, right? The statute of limitations, right? Failing to seek medical treatment timely. If you waited forever to seek medical treatment, that can also hinder your claim, depending on the other circumstances. And finally, they will claim you did not suffer an injury by accident arising out of or in the course of the employment. I have other videos, and my website addresses specific injuries by accident arising out of or in the course of the employment. So I strongly encourage you to check those out. If the 20-day order denies, the 20-day order response form filed by the employer and the workers' compensation insurance company denies the claim, the injured worker should contact the commission and request that the claim for benefits be referred to the hearing docket. The commission will then set a hearing date, and the parties will proceed to conduct discovery, develop evidence, and prepare for trial. See my other video on my website about conducting discovery and what discovery tools are available. Another ninja tip. And this one's important. All of them are important. That's why they're called ninja tips. Sometimes injured workers will feel like it's like a small victory, right? They'll be excited about the fact when the insurance company and the employer say they've accepted a claim. But when they do that, and they know the injured workers are excited about that. When they do that, they'll, on the award agreement form they send, it will have not all of the injuries claimed, or it will have not all of the wage loss replacement benefits claimed, right? And they're hoping that the injured worker, not being an attorney and not necessarily understanding it like they do, doesn't notice it, or notices and says, well, that's fine, I don't care. I got most of what I wanted anyway, okay? Injured workers should review the award agreement form to make sure it accurately lists all body parts injured, because sometimes it can be hard to come back later and claim those body parts, okay? And it should also provide all of the wage loss replacement benefits to which the injured worker is entitled. And I know that's hard to determine sometimes, but it's important. It's important to not agree, because sometimes in certain situations it can be difficult to come back later, a year or 2 or 3 years later, and claim that was wrong, right? When you entered that agreement 3 years ago, okay? Obviously, if you review the award agreement form and it is accurate, sign it and return it. The commission will, and when you return it, they'll probably have instructions for you to return it back to the insurance claims adjuster. They will then sign it and file it with the commission. The commission will then enter an award order awarding you the benefits agreed upon in that award agreement form. So that's how that works. Occasionally, even though it's a 20-day order, the employer and the insurance company will basically ignore the order, and unfortunately, there's really no remedy for that. There's no bite, so they don't really get punished. They're penalized. It's after a certain amount of time, the commission will treat it as a denial. But if the injured worker doesn't want to wait on that, if they're just kind of not responding at all, and it seems like everything was sent into a black hole, the injured worker can again write the commission and say, hey, could you please refer my claim for benefits to the hearing docket? One last thing I wanted to mention about the claims process and kind of some benefits from that. And this is a good reason why injured workers should file their claim for benefits sooner rather than later. once an injured worker files his or her claim for benefits, there are certain protections available under the Virginia Workers' Compensation Act. For example, Virginia law prohibits debt collection activities by medical providers and any debt collection agency they use, okay, for bills related to treatment of the injuries from the work accident. So people, by law, once you file a claim, you can say, I filed a claim, this is my claim number, don't contact me anymore about these medical bills. It's a disputed claim. It should be workers' comp covered, right? Similarly, Virginia law also prohibits healthcare providers from asking the patient to pay the difference between what the workers' compensation insurance company paid and what the healthcare provider is charging. Okay, that's called, also referred to as balance billing. The Virginia law prevents that as well. So that's some other small benefits. But look, if you've been hurt and you're out of work and you don't have money, you certainly don't want to worry about additional medical expenses on top of it. So they are beneficial. They're helpful. All right, so I think that's all I want to say today about kind of an overview of the Virginia workers' compensation claims process and what happens after the accident, kind of behind the scenes. I think it's helpful for injured workers to know that so they can kind of understand why sometimes there's a delay or what's going on or what they should do next, okay? For more information, again, check out my website, www.hurtatworkinva.com. That's www.hurtatworkinva.com. You can also follow us on Facebook, Twitter, or YouTube. YouTube has a bunch of the videos. And you know, if you've been here's the thing. If you find this information helpful, and that's what it's designed to be, then if you find it helpful, chances are other people may find it helpful. So if you have family or friends who have a workers' comp claim, work injury, or whatever, or know someone else who does, like, tell them about my website or my videos, right? That'll allow them to gain knowledge about what they're going through, because it's very frustrating. I understand. I was hurt at work before I became a workers' compensation attorney. I didn't know what to do either. It is what it is. But I feel like it's better, if you refer it to people and they see it, at least they have the information. I feel like it's better to have the information and not need it than to need the information and not have it and not know what to do, okay? That's all I got. Until next time, stay safe and don't get hurt at work.